May it please the court, good morning. My name is Heather Grave. I represent the appellant 2408 West Kennedy LLC. And with me at the table is Mr. Bart Meacham. He represents both appellants, and he and I have spoken and have agreed that I will take the entirety of the argument today. And I would like to reserve 5 minutes for rebuttal.
Yeah.
May it please the court, the November 25th, 2020 order granting appellee's emergency motion for enforcement of the writ of possession and its underlying May 8th, 2020 non-final order, which merged into the November 25th order, should be reversed because the appellants were never made parties at the underlying final judgment level, and were never given a notice and opportunity to identify their rights, identify the priority of their rights with respect to that of the plaintiff. And so therefore the writ of possession should not have been enforceable as against their non-party, non-adjudicated rights. They had a possessory interest in the property pursuant to leasehold 2007 leases entered into by both of them with the defendant in the case, BAMC, and those possessory interests were never foreclosed.
Mr. Groff, you would agree that this procedurally, this case is sort of a hot mess, right?
I would agree that thanks to a lot of post-judgment efforts that it is somewhat confusing. However, there is no doubt that the November 25th, 2020 order, the language of it, adjudicates rights of the appellants that the appellants had to appeal because they had not been properly given notice with respect to those rights.
So even though they had moved to intervene in the post-foreclosure judgment, your position would be they were never obligated to intervene under the statute because they had been tenants in possession the whole time, right?
Yes, Your Honor, that is exactly right.
So that's why their subsequent withdrawal of the motion to intervene shouldn't be a factor in considering the propriety of the trial court's action.
Yes, for 2 reasons. One, because the final judgment on which all of this post-judgment action was related, they were never given an opportunity, and as Your Honor mentioned, they were not required to because they were in possession. So even though that at the commencement of the case they may have had an unrecorded interest, they were persons in possession, and so Section 4823 doesn't apply to them.
So they could have filed a separate deck action?
They could have filed it, I believe that they did.
But they sought to they sought to intervene, right? And they chose not to appeal the order after the intervention. And then, so why are their interests not foreclosed by failing to appeal that order?
With respect to the intervention order, they did move to intervene for the limited purpose of objecting to the sale.
And didn't they raise their rights, their leasehold rights during that time in the motion?
I don't know that they raised them as being ripe for adjudication, but rather to identify why they were persons who would be.
Right, because they had leasehold interests, right? I mean, that was their objection to the sale.
Right, but Your Honor, they intervened. They moved to intervene only for the limited purpose of objecting to the sale. And you're right, they did not appeal the order with respect to the sale. Even though there was language in that order that suggested a finding of fact by the judge with respect to the priority of their leasehold rights vis-a-vis the mortgage lien. That was just dicta. It was not a final order.
Wait. How do we have dicta in a trial court ruling?
Well, I would say it's a finding of fact. It's not an adjudication of final order that adjudicated their rights. It was a statement that was made that was irrelevant to the order, which was the order.
So I'll play devil's advocate on that just a little bit. So you have parties proactively seeking to intervene in pending litigation, identifying what they believe their rights are in property. You have then a hearing, you then have a ruling that that appears to, you're characterizing it as dicta or an unnecessary factual finding or what have you, but appears to impact the very rights that they identified in their motion. But that's not enough to trigger a requirement for them to appeal an order that precipitated from a hearing that in turn came from a motion to intervene. And I'll tie this all up in a knot and then I'll be quiet. My concern with all of this is that at bottom, what you are arguing is premised upon the notion that my clients were deprived of property right without due process. But there's a substantial amount of law that suggests that if you are there in litigation and you have the opportunity to raise your rights, as it appears may very well have happened here, that's what you're promised and that's what you've been given. So help me out with all of that.
Sure, so the intervention order, and it's called the intervention order, but really, with respect to what Your Honor is discussing, it was the order overruling the objection to the sale. And the objection to, and frankly, the objection to the sale was not well taken, and so that was, you know, so that was not a reason to there was no reason to appeal because it wasn't attacking the propriety of the sale, which is, you know, an objection to the sale. That's very limited grounds by which you can do that. That is different than when there was the issuance of the writ of possession, and then there is this November 25th order enforcing the writ of possession, where very clearly Judge Stevens is directing by injunction, you know, which appellees asked for, directing the appellants to peaceably leave the property, and they are ordered to peacefully leave the subject property and not interfere with execution of the writ of possession. So that's when we get to, now we have a final order that's telling them they no longer have possessory interest in the property. You know, the order on the objection to sale.
I kind of liken that a little bit to the idea of, I mean, it almost reads like a contempt order, which if you were to run with that analog, the law is pretty well settled that contempt and the underlying order that the contempt is pertaining to are two separate things. You got to appeal the former, and you can't just go after the latter and try to attack the former.
Well, I guess my response to that is the order on the objection to the sale, all it does is verify that the sale is valid. But so the sale is valid, so the purchaser at the foreclosure sale takes subject to any omitted junior lieners or any junior interests. And then it's incumbent upon them to then file a re-foreclosure. So that's all we're saying that needed to happen, but instead of doing that, they went through and they obtained a writ of possession and then had that writ of possession through this November 25th order be pertain to the possessory interest of the appellants, even though the appellants had never been given an opportunity at the pre-judgment stage to file an answer, to identify their interest, to identify the priority of their interest with respect to the mortgage lien. And so that's where the issue is that the because the sale could be ratified and still the appellants have their
If they were granted intervention, even a limited one, couldn't they have requested at that? They now have their foot in the door, so to speak. Couldn't they have requested, Judge, we'd like to close out the pleadings and file an answer and file affirmative defense? Was that request ever made?
I don't believe that it was.
Is there a timely appeal of the writ of possession that was entered in May 8th?
Well, as the appellants, as the appellees rightly noted, it's an order that's it's a non-final order that could be appealed under Rule 9.130. But also, as I know Your Honor is aware, you know, Rule 9.130 specifically says that it does not foreclose a later full appeal once the final order is entered.
And it's absent from the notice of appeal.
Right, it is absent from the notice of appeal. It's not identified as being, and I would only guess that appellants feel that order merged into this November 25th order that clearly forever forecloses, directs the appellants to leave the property and forecloses their possessory interest.
But the latter writ in November is an enforcement order, very different from the original writ.
Right, it's
You'd agree.
enforcing the writ of possession.
Right, the underlying writ.
Right, and the, the appellants sought rehearing, whether that can be read as a motion to dissolve the writ or rule it unenforceable, I don't know, but the November 25th order was timely appealed, and it's the one that very clearly and finally tells the appellants you no longer have.
But
accessory interest.
if we can't consider the appeal of the underlying writ, which was entered in May, what are you left with?
Well, in that case, the writ of possession in that case, and this goes to some of the inconsistency in appellee's argument, because the appellees all along and even in this appeal have said that our appellants lacked standing to object to the sale, that they lacked standing to oppose the writ of possession. But then at the same time, they're saying, well, we should have appealed the order. The fact is that we weren't a party pre-judgment, and so our rights were not adjudicated in that final judgment. So whether we were even a party that was necessary to appeal is a question. But very clearly, the November 25th order.
But isn't there something to the fact that when you had the opportunity to intervene and you stepped into that arena and you intervened and then you withdrew it? I mean, isn't that something that we should consider as far as a waiver argument?
I think that the idea was that they wanted to intervene for the very limited purpose of objecting to the sale. So it was intended to be a limited appearance, as it were, objecting to the sale.
Is that how they appeared when they filed the motion to intervene?
I'm sorry.
Did they file on a limited appearance or just filed a motion to intervene?
They filed a motion to intervene at the hearing. It was very clear, it was made clear by both parties that it was only for the limited purpose of adjudicating the objection, and then Judge Stevens adjudicated the objection.
I don't, but the motion to intervene itself seeks to intervene for judgment in its favor, declaring the commercial lease agreement attached here to survives any foreclosure sale, et cetera, and the motion for intervene is separate from the objection to the sale. And so it's not at all clear in the motion to intervene that it's limited to the purpose of objecting to the sale.
Right. And I understand. I'm really just quoting from the transcript of that hearing, where it seemed that all parties were in agreement that appellees were only willing to agree to intervention for the purposes of the objection, and that the appellants were only seeking to intervene for the purposes of objection. And then they withdrew, but at all times they have maintained that, look, we were never a party. We were never a party to this foreclosure action. And so what needs to happen is that the purchaser needs to re-foreclose, and then we have defenses for why our possessory interest should be superior to the interest of the mortgagee.
But I go back to the question earlier, which is that if your clients were granted intervention, even on a limited basis, and they never requested the opportunity to file pleadings to make the issue, put the issue before the court, just let us file an answer and affirmative defenses so we can put this issue into play. Is that a waiver? Isn't that a waiver? Because certainly, if this weren't post-judgment, basically post-judgment enforcement proceedings, if this weren't in that context, there'd be no question that their failure to file an answer and affirmative defenses after successfully gaining some intervention would have been a waiver of whatever defenses they wanted to raise.
I understand your argument. Not your argument, your question to me.
It's a concern. It's a concern.
I understand the question, and what was brought up was that there are other avenues that perhaps could have also been pursued, such as filing a deck action. But in this action, it's not that the appellants have ever stepped away from their argument that, hey, I want this court to know we were not a party to this, and we are in possession. You need to know that we are not a party to this. We should be a party to this. That statement, the appellants never never wavered in the other meeting, the term wavered. They never wavered from that position, that we should be parties and we are not parties. And so this final judgment is not enforceable against us because we were not a party, and any post-judgment orders that that flow from that are not enforceable against us unless and until we remain a party and given an opportunity to present our defenses.
Mr. Gray, just to let you know, you're right at your 15 minutes. If you want to reserve our time, or you can continue.
Okay, let me just touch on one more point. One important point that I do want to raise before I reserve the rebuttal is that there was an amended complaint filed by one of the successor plaintiffs. And in that amended complaint, all tenants were dropped from the action, whether it be unknown tenants or any other form of tenants. And the law is clear that when you have an amended complaint that drops parties, that drops causes of action, unless you specifically preserve those, the amended complaint supersedes. So that puts people like the appellants on notice that the plaintiff is not seeking judgment as against their interest. And so they are not put on notice that they need to intervene at that point. So I will leave it at that, and I will reserve the rest of it. Thank you.
You have 4 minutes remaining. Thank you.
May it please the court. Good morning. My name is Christopher Summers. I'm with the law firm of Burr & Foreman, and I'm here on behalf of the Bank of Central Florida, which is the appellee. I'm also joined by my colleague, Dan Robbins, from our Tampa office at Burr & Foreman. To your point, Judge, this is a bit of a hot mess procedurally, and so what I'm hoping today to do is to be able to somehow make some sort of clarity on what we have going on here. That's my goal. I hope that I can get it done. I think I try to make things simple in my head when we're dealing with stuff like this while this is complicated. But I think at the end of the day, we have one order that has been appealed, and that's the order dated November the 25th, 2020, which in my review, in my look at it, is very limited to dealing with personal property, 2 trailers being removed from real property, and that particular order related back to the May 8th, 2020 order, and it's an enforcement of that trial court's previous order. So then we have the appeal of that one specific order, very narrow. We don't have any real briefing or any argument related to the personal property that is the subject of that 11/25/20 order. And I think that it's really just that simple, because what this seems to me to be is a collateral attack of 2 other orders, the May 8th, 2020 order, and then the intervention order, the March 5th, 2019 order. And so it is the avenue through this one order to try to attack those other 2 orders and the issues contained therein. But I believe that on both of those orders, this court doesn't have jurisdiction to deal with those because they weren't appealed. They're not in the notice of appeal and they weren't timely appealed. So I think, and I try to make things super simple for myself, and I try to make it super simple for you guys, but I think that based upon that, we're dealing with the appeal of one narrow order. And you can PCA that based upon everything in the briefs and the fact that it seems that there's been abandonment of anything related to the personal property, to the 2 trailers. Nobody really talks about that in the actual appeal. Now, to the extent that this court wants to look behind to those other 2 orders, I think that we can dispose of those pretty quickly. And this is where I try to cut through the hot mess, is that let's look at the 5/8/20 order, which is the order granting the writ of possession. That's an appealable, non-final order that has to be appealed within 30 days. It was not appealed within 30 days. Thus, this court has no jurisdiction over that particular order. Now, the argument is that there was a motion for rehearing and a motion to vacate, consolidated motions, to then challenge that particular order. But it doesn't toll rendition of that order because the motion to vacate and the motion for rehearing are not authorized orders pursuant to the Florida appellate rules. And thus, 30 days was running and there's no appeal. I think that's pretty simple, thus no jurisdiction. Now, let's quickly turn to the intervention. March the 5th, 2019. This was a little bit more complicated, a little bit more intellectually interesting. Granted in part, denied in part, granted in part for the sole purpose of dealing with that objection to sale that was filed contemporaneously with the motion to intervene. Denied in part for all other respects, any kind of intervention argument. But in that same intervention order on March the 5th, 2019, the court, for the limited purpose of the objection to sale, denied the objection to sale. Thus, what we have effectively is a final order across the board for all intervention, whether it's the denied in part or the granted in part. So said another way, there are no open intervention issues after the March 5th, 2019 order. Thus, that was a final appealable order that was not appealed within 30 days. Thus, there's no jurisdiction on y'all's part, I'm pointing to myself, on y'all's part, to deal with that particular order. Now, if I'm reading the papers correctly and understanding the arguments, is that I believe Appellant is arguing, but granted in part, denied in part, the granted in part portion made the entire order interlocutory. There's no case law cited in the papers for that. I think that's probably intellectually not the best way to look at it. Intellectually, I think you could say maybe the granted in part was interlocutory in itself, but the denied in part was final.
The problem that you're touching upon is that all of these orders are post-judgment orders. There's already a final judgment that's been entered. Everything that's coming now is post-equitable, post-judgment stuff, and so it's never going to be a perfect fit in any of these silos.
I understand. That's why I'm giving you my best
Yeah.
my best take on it, right? The way that I think that is probably the best way to look at it. So even if this court were inclined to believe that some portion of it or all of the intervention order is somehow interlocutory, we still then come to the point where they withdrew intervention, where appellants withdrew intervention, and thus, so either the order was final in all respects and there's no appeal, or intervention is moot. Either way, it's not before you guys. That's essentially how I see it. That's how we've argued it in the papers. And I think from the overall standpoint, the only order that's before y'all is the 11-25-20 order, and its limited purpose of enforcing the court's previous order on May the 8th of 2020. Enforcing that order, thus abuse of discretion by the trial court would be the appellate standard. There's no allegations about abuse of discretion as it relates to this particular order on appeal, as it relates to the trailers. And for that reason, I believe that you guys can PCA the 11-25-20 order. I know I haven't used up all my time. I'm happy to answer any questions if you guys have them. Thank you.
Thank you, Mr. Summers.
Your Honor, I want to touch on a couple of things. First of all, I want to touch on the very first point with respect to the subject matter of the order of appeal, that it was limited to enforcing possession of the trailers that were on the property. Nowhere in the November 25th, 2020 order is the word trailer mentioned at all. I understand that maybe plaintiff, appellee as plaintiff, was seeking in the motion mention of possession of the trailer, but nowhere in this order is that mentioned. What is mentioned is appellants, you must peacefully leave the subject property. All rights associated with all rights under any 2007 leases are extinguished by the failure of the source of their leasehold rights to pay the mortgage on the property and their failure to come forward. All of the defendants in individual or corporate forms are now precluded from asserting a right of redemption, much less vitiating the entire judicial process to date. That is the order. That is the final, and it has its language that has finality. It sounds like a judgment, even though my client was never named as a party, given the opportunity to defend itself. There was no mention of the trailer. Second, with respect to the discussion of the May order, well, I want to go back to the March 2019 order. I don't believe that we're seeking review of that March 2019 order. We only mention it to identify the limited purpose by which the limited purpose of that order, which was simply to adjudicate the objection. We are seeking review of the May 2020 order, as it being, as appellees keep mentioning, a non-final order that merged in. It was either a non-final order that merged into the November 25th, 2020 order, or it was itself a final order, in which case the appellant's filing of a motion for rehearing told the time for appeal. So the order was the issue with respect to the writ of possession and the enforcement of the writ of possession we have timely review of that order. I wanted to address the question about why wasn't our withdrawal a waiver. Well, it's because we were not obligated to intervene. So we intervened for limited purposes, but we were not obligated to intervene for other purposes. And we kept bringing it to the court's attention. Look, we're here. What needs to happen is that the subsequent purchaser needs to re-foreclose our rights, and then we can present our defenses. But that never happened. So we were not obligated to intervene. We just wanted to bring to the court's attention that our rights did exist and needed to be adjudicated before we could be dispossessed of them. So with that, I'll ask that the court reverse the November 25th order, 2020 order, including enforcement of the writ of possession and remand for further proceedings. Thank you.
Thank you all.
Thank you.